Asbestos was one of the great industrial tragedies of the 20th century. Workers who were involved in mining and processing asbestos fibres were gradually understood to be at terrible risk of developing asbestosis or mesothelioma, fatal types of lung disease which caused terrible suffering before death. In this case, the plaintiff, Joyce Bale, was never involved in the asbestos industry. Her husband worked for 3 years as a processor at Seltsam Proprietary Limited, a factory processing asbestos products. He brought home asbestos dust on his clothes and in his ute. Justice Hellman noted, there was much evidence about the knowledge scientists had gained in this century about the damage that the breathing of asbestos dust can do to the human body. Knowledge on this subject increased greatly as time went on. At first, scientific interest concentrated, understandably, on the effect on those most exposed to the dust, the workers in the asbestos industry. Gradually, however, it began to be understood that other people who were not exposed to such large quantities of the dust as workers were could also be affected. Seltsam Proprietary Limited didn't have much sympathy in the court. As a company, they were known to have been very cavalier about the safety of their workers when it came to asbestos. A simple Ostley search shows many cases against them by workers. The question in this case, though, was whether Seltsam had owed a duty of care to Mrs. Bale. In other words, was it reasonably foreseeable that their failure to protect Mr. Bale from asbestos exposure would cause harm to Mrs. Bale? At first instance, the judge reluctantly said no. Her Honour found that at the time, 1962 to 65, there was simply insufficient knowledge about how little of an exposure was necessary to cause dust diseases. On appeal, Justices Macpherson and Hellman agreed. Justice Hellman said, at the relevant time, that consequence was, having regard to the state of scientific knowledge on the subject, not reasonably foreseeable. It was not far off being so, because the connection was on the point of being revealed to the scientific world, and through it to the industry and public health officials. It was regrettably too late for the appellant's well-being. This case confirms that for liability to exist in negligence, the harm to the plaintiff must be reasonably foreseeable to the defendant at the time of the negligent conduct.